University of Alaska Disability Services Annual Conference. All access, all the time. Sharing space together. When we come together online, we often don't feel connected to our land and can mistakenly imagine ourselves as disconnected from physical space. In reality, we join these virtual sessions from offices and homes built on the traditional, unceded lands of Indigenous tribes and peoples across North America. Disability Services would like to express gratitude for access to this beautiful, majestic land and for its caretakers. We also acknowledge that our shared virtual space exists because of physical infrastructure. Zoom servers connect us based on resources and availability. When you join us virtually, you're borrowing resources from other communities that make this sharing possible. If you don't know the Indigenous history of the land you occupy and would like to learn more, please visit native.land.ca. The University of Alaska acknowledges the Alaska Native Nations upon whose ancestral lands our campuses reside. University of Alaska Anchorage.
Dena'ina, Atnadine, Alutiiq, Sugpiaq, Chugachmute, and Eyak peoples.
University of Alaska Fairbanks.
Dina people of the lower Tanana River.
University of Alaska Southeast.
Tlingit, Haida, and Tsimshian peoples.
Welcome to the session.
Good morning, everybody. So we are talking today about kind of the legal landscape that we work within. Originally, this session was advertised as going to be presented by General Counsel. Unfortunately, due to scheduling conflicts, they weren't able to participate today. So we still wanted to make sure that we provided some background and information and case studies about the law that applies to higher ed and our institutions in regards to working with individuals with disabilities at our campuses. So over the last 2 weeks, we've been talking about all of the different things that we do within our offices. So now we get to kind of look at why we do the things that we do in disability services. So Anne is presenting with me today from UAA Disability Services. And I'm sorry, I forgot to introduce myself. My name is Amber Kagwin. I'm the director of UAF Disability Services on the Fairbanks campus. So a little bit about what we're going to be looking at today. We're going to be talking about, kind of how we got to this point and some of the things that led to the laws that were put into place around disability rights. We're going to do kind of a run through of the laws that apply to the work that we do. We're going to talk about some of the do's and don'ts about how those laws are implemented within the systems and ways to potentially avoid some issues. And then we're going to talk about who is responsible for the enforcement and the responsibility, who has the responsibility on our campuses to follow the disability laws. This is a quote that I thought was helpful to consider as we talk about our topic today. It's from the Understanding the UN Convention on the Rights of Persons with Disabilities. And it says, as we witness a global shift from the old individual and charity models of disability to the social model, the understanding of and hence the action taken on disability issues has changed from considering persons with disabilities as objects of pity to persons with human rights. We also wanted to share a little bit about some of the language that's used within the disability community and when working with individuals with disabilities. This was taken from a written guide on how to write about people with disabilities from the ADA National Network. So first of all, consent is really important when you're working with somebody who has a disability. You need to ask to share their status with others. You don't want to bring it up if it's not relevant or if you don't have their permission. You want to emphasize ability. You want to talk about a person who uses a wheelchair versus a person who's confined to a wheelchair. It's making sure that that person first language is part of how we communicate about disabilities. And that means that we're emphasizing the personhood, not the disability as an identity. There are people who do prefer to have the identity first. So a disabled individual or a deaf person rather than a person who's deaf. So that it's really important that you ask what their preference is and how they'd like to be referred to. Also, we want to try and use neutral language, avoiding tropes of victimization, illnesses, or the mental health stigmatization. So watch how we reference people without disabilities too. So a few more things, just so everybody knows. These materials are provided for informational purposes only and are not to be construed as legal advice. We are not lawyers. We do not represent the university as lawyers. We are professionals in the disability services field within higher ed. And so for any legal guidance or questions, you should seek independent or our general counsel to help resolve legal issues that you might be responsible for or that you're addressing. And further, if any policies or procedures, if you want to add or revise things following this conference, if you're thinking about how this all can apply to your maybe department or the area that you work in, before you go into publishing those, you really should have those reviewed by our general counsel to make sure that it's meets the letter of the law and is good to go for your implementation. Our presentation style today, as we've done with our other sessions as well, we want this to be a discussion. So if there are questions as we're going through, please raise your hand or turn on your video and put something in chat. However is best for you to communicate. Our chat is being watched today by our colleagues, and they'll let us know if a question comes up or if somebody has their hand raised. So please feel free to jump in with questions, because it's more than likely it'll be easier to answer it as those questions come up than to wait till the end. If you feel better waiting till the end, that's fine too. All right, so let's dive in. The road to disability rights. So first of all, we want to make sure that we are all speaking the same language in terms of what is a disability. So the legal definition of a disability or a person with a disability is a person who has a physical or mental impairment that substantially limits one or more major life activity. This includes people who have a record of such an impairment, even if they do not currently have a disability. It also includes individuals who do not have a disability, but are regarded as having a disability. It's estimated that 1 in 4 adults in the US has a disability. And about 1 in 5 undergraduate students report having a disability. So that's 20% of our student population say that they have some sort of disability, but the majority of them do not formally request accommodations, academic or otherwise. We had shared earlier in this conference that each of our campuses has about a 4 to 5% of the student body that we work with that have identified as having a disability and requesting accommodations. So when we look at the national numbers that say about 20% of our student population has a disability, we are serving a very small portion of those individuals. A disability will also cover somebody who has age-related impairments. So as people get older, they may have reduced vision and hearing abilities. And so just as part of their aging process. And so those are also covered under ADA law and the laws that we'll be talking about as being a disability. Some temporary conditions can be viewed as disabilities. And on our campuses, we try to work with individuals who do have some sort of temporary condition that needs to potentially be accommodated. For instance, if somebody breaks their arm or their wrist and they're not able to write in class, we would work with them to provide accommodations to allow them to still be able to complete their work without the requirement of handwriting.
And that currently includes the long-term effects of having COVID.
Yes, it does. Thanks, Anne. And the impairments around are caused by drug and alcohol addiction are really complicated. It's an area that we're not going to go into a lot, but essentially individuals who are no longer active in their addiction, but there's things, the barriers or things that have developed because of the drug addiction or alcohol addiction, they may still qualify for services as an individual who has a disability. So before disability rights were implemented, and this is primarily looking at Western cultures, specifically the US, we used a medical model, and that really siloed individuals by their diagnosis. So it essentially said, you know, if you have this kind of disability, you're not going to be able to participate in our communities the way that other people will. So, you know, they already kind of paint you into a corner. There was a lot of stigmatization, which varied by the diagnosis, class, gender, and race. So we see a lot of dual issues there because not only do they have a disability, but they're also of a particular gender or race. And so it amplifies and complicates things even further for those individuals. There was widespread institutionalization of individuals with disabilities, and that was a fairly common practice. And there was also forced sterilization for individuals with disabilities that continued up into the 1960s. The civil rights movement provided an opportunity for individuals with disabilities and advocates for those individuals to kind of build upon the expertise that was gained by the African American civil rights movement. So it kind of gave them a platform that was already being looked at and seen. It was very visible. And so they started participating, individuals with disabilities and their advocates started participating in more and more of those civil rights movement activities to also make sure that disabled individuals were included with that movement. It really brought in the power of identity and provided some opportunities for coalition building. And by the 70s, there was a generation of polio survivors that were in their 20s and 30s who were all disabled, who also participated in a lot of the movement activities. And the photo here is a picture of individuals in wheelchairs at a rally of some sort with a banner over the top of them that says, "Injustice anywhere is a threat to justice everywhere." And that's a quote from Martin Luther King Jr. So that's a little more about how we got here. We're going to talk now about the laws that we work with that apply to individuals with disabilities currently. So can anyone provide, or does anyone know of any of those laws or what the names of those laws might be? You want to share those in chat, get a little participation going. It can be any of the federal laws, the regulations. Yep, the IDEA, Section 504.
Yep, motor voter laws.
Mm-hmm. Americans with Disabilities Act, the ADA, that's right. Yep, and we also have state laws. Another one is the FHA, federal housing. And there's more, but that's kind of gives us a good span of what we're going to be looking at specifically. So the laws that apply to our work, within that, there's kind of a hierarchy of what laws oversee the other areas. So which ones are most important, which ones we have to pay attention to first, and then we kind of work down from there. So first and foremost, law of our country is our Constitution, and then the amendments to our Constitution. So that overrules everything. But then we come into the laws and statutes that are put into place through the federal and state systems. And so our federal laws are then first, and then our state laws follow after that. We always do follow the most restrictive of the laws. So we make sure that we cover all of our bases. So if the state law allows for certain things, but the federal law doesn't, because we're a federally funded institution, we would go with our federal laws. It depends on how that law applies to individuals. So if the state laws are less restrictive in terms of allowing more opportunities for individuals, then the state law is the one that we would use because it's more beneficial for the individuals. Then we have judicial precedents and the court orders that come along with that. So as the courts are making decisions on cases, that provides some guidance as to how we apply our laws. And then lastly, we have agency guidance and consent decrees that come through our regulations and executive orders. So that's kind of the last of the steps, but those letters that we might get from OCR, the Dear Colleague letters or resolution agreements that are put into place, the guidance through our regulations, those all help form our policies that we have to put into place within the institution. So in 1973, the Rehabilitation Act was put into place, originally talking about Section 504. The regulations started, the Rehabilitation Act was proposed in 1973, and there was quite a bit of a fight over the regulations and how it was going to be applied. And it wasn't until 1977 that things finally were settled. But that outlined Section 504 that talks about the individuals with disabilities and the benefits that they have and would be afforded in our communities. Section 508 was implemented in 1986 as they realized that, oh, wait a minute, we also have computers that we need to think about and providing access to individuals with disabilities to the information that's online, shared through computer or technology use. And then in 1990, the ADA was signed into law. The regulation was written and it's been amended since then with additional information. But that's kind of the timeline for when those laws were put into place. The Rehabilitation Act of 1973 focused in terms of how it applies to higher ed. They were talking about non-discrimination at federal institutions. So not only prohibiting employment discrimination at federal agencies and contractors, but also introduce the term qualified individuals with disabilities. And qualified means that the person meets the requirements of employment and can complete the essential function of the job program with or without a reasonable accommodation. And that can be applied to higher ed just simply by changing employment in several of those places to meet the requirement of being a student and can complete the essential functions of the program or coursework with or without a reasonable accommodation. Section 504, or anything that's federally funded, which includes the UA system campuses, is a much wider scope. It actually covers any program or activity receiving federal financial assistance. And so that's where the non-discrimination that was set up at federal institutions then applies to higher ed. So again, it covers education, healthcare, social services, and it's not just for employees and job applicants, but all participants in those programs, whether they are a student, a member of the public, somebody who is utilizing the campus for their benefit. They might use our libraries, but they could be a member of the public. Information for the Section 504, there's a link there. So when this is shared out, you'll have that link. So when we talk about otherwise qualified, we kind of want to get into a case sample. So I'm going to hand it over to Anne.
So this Southwestern Community College versus Davis was one of the first cases where they looked at otherwise qualified. So in 1979, a hearing impaired student applied to be in their nursing program, although she was unable to satisfy the requirements of the program because she needed to lip read during clinical rotation, and they were not able to accommodate that. So they said that she couldn't be in the program. They weren't going to waive the clinical component of the program, and they would not sign an aid to help her communicate in her clinical rotations. So the question was, could the institution have this qualification for admissions to a program? And would accommodations be reasonable? And we'll talk about that a little bit, because in 1979, the court ruled that the student was not otherwise qualified to be in the clinical portion of the nursing program. So the school actually won this case because of that, because the student was considered not otherwise qualified to be in the program. Because otherwise qualified means with or without accommodations, they did not see at that time that there were accommodations that would help the student be successful in the program. So the thing to think about, though, is that 1979 didn't have the technology that we have today. And if you were part of the fundamental alteration presentation that I did last week, now they actually have blood pressure machines, EKG machines, stethoscopes that give visual information. There's a lot of interpreters that now are in hospitals and can do rotations with students, with people in clinical rotations. So all of these things wrapped together, we start to think about otherwise qualified can really depend on the program and can depend on what would be considered a fundamental alteration of a program.
Just because they've done it that way in the past doesn't necessarily mean that that is going to be precedent for how things are done in the future. And that as technology changes, who is otherwise qualified can change significantly. In 1977, that was where the Rehab Act was essentially unenforceable because they didn't have the regulations and guidance. They put the law into place in 73, but they didn't really have a way for people to interpret it. The courts hadn't made decisions on it. It was essentially just kind of a law that didn't have any teeth. So there were a lot of contradictory court rulings. Lobbyists were adding loopholes and exemptions to proposed regulations. There was a lot of civil rights activism by people with disabilities that occurred across the country, including the San Francisco 504 sit-in, which my understanding is still the longest sit-in that occurred in a government building. I believe it was 20 days. You know, all of this was happening because essentially this law had been put into place, but no one could do anything with it or enforce it because they didn't know how. And so the civil rights activists essentially prevailed, and the Carter administration passed the original draft of 504. They signed it finally, unchanged from what it was originally. And then Section 508 of the Rehabilitation Act was added in 86 to cover electronics and information technology used by federally funded organizations. There were revisions in 98 and 2017, and likely to be more as technology continues to change. And given the rate of how quickly our technology changes and how slow the United States acts are to be modified, most people will rely on the International Web Content Accessibility Guidelines, or WCAG, and those standards are pretty good about staying current on what digital accessibility means. So that tends to be the standard that is used. And I'm going to hand it back over to Anne to talk about Penn State.
So when Section 508 came into play, there, of course, was a complaint. And this complaint was against Penn State by the National Federation of the Blind. It did not go to court. It ended in a voluntary resolution agreement. And Penn State had a couple of years to make changes that would satisfy the complaint. It was one of the most extensive agreements that a university had made, and really set the stage for every other university to follow up on these kinds of things related to accessibility. So they had to do an audit for their websites, for all their software, and they had to make a plan to correct all of those issues. They increased their staffing related to accessibility. They had to have training for all faculty and staff. They had to have a new web accessibility policy written. They developed policies for purchasing accessibility and purchasing software and other products to ensure that they were accessible. All the websites had to be at the WCAG 2.0 AA compliance, including the library and the search engine for the library. They actually had to replace their learning management system. So whatever they were using, like Blackboard, they had to replace. They had to adapt their podiums, displays, clickers, and other in-class features so that they were all accessible. And if they had anybody on contract or providing services on campus, including their ATM machines, they all had to make sure that they were accessible. So that was really a landmark. And then if you want to go to the next slide, Amber. Just recently, there was a complaint by the National Association of the Deaf against Harvard and MIT, which was, again, they settled with a voluntary resolution agreement in 2020. And this had to do with their online programming that was not captioned. So anything on YouTube, iTunes, their website, course materials, they were not accessible to deaf individuals. So it also increased the quality and accuracy of the captions provided on those materials. So auto captioning at best is 70% correct, which means 30% of the information is being lost. Under the law, we actually need to get to 99% accurate, which is why we have a live person doing transcription so that we have accurate transcription, and we can as an accurate 99% captioning to our recordings. So again, this was recent and one of the most comprehensive cases that supported that accurate captioning for all content that was accessible. So if you don't know, most people knew because we all had to go to training, that UAA had a complaint back in 2018, and we entered into a voluntary resolution agreement to make sure that our websites were accessible. And it is why we continue to have accessibility training for web designers. All faculty and staff had to take the training, and we had to have everyone trained and in line within 2 years. We are no longer under the voluntary resolution agreement, but that training and that expectation that we satisfy the WCAG standards continues still. I see lots of things happening in the chat too, so.
Looks like there's some recommendations for a book, Being Human by Judy Heumann and Kristen Joyner. So that one's an unrepentant memoir of a disability rights activist. And then a movie recommendation, Crip Camp, A Disability Revolution, that should still be on Netflix. Thanks for those, Jenny. So the Americans with Disability Act of 1990 came into play. So Section 504 regulations had become law. It expanded Section 504 by requiring accessibility in nearly all public settings, not just the federally funded ones. Title I of ADA covers employment. Title II covers government and transportation. Title III covers public accommodations in commercial facilities. And Title IV covers telecommunications. So for our campuses, we fall under Title I requirements for employment. We are a government entity. We are funded by the government. So we fall under Title II as a public institution for higher education. Title III, public accommodations in commercial facilities for places like the bookstore at the UAF campus is a contractor. It's a private business, but they are on our campus. They fall under Title III requirements, and our communication with individuals, Title IV. So a lot of the laws apply to our campus in different elements. So it's important that we're aware of all of those things. Then there was a major revision in 2008 that broadened the definition of disability, and it strengthened the position of the people who were alleging discrimination. I see more things happening in chat. What's going on?
Got a question. Because we've already had a voluntary resolution agreement, does that mean if there are issues in the future, we are more likely to get in trouble with OCR? It's a great question.
I would say yes, because they've already come into an agreement with us, made us aware of the responsibilities and the requirements, and to not follow that at this point, there could be additional requirements or potentially even financial requirements for us to pay for not following the laws. Anne, do you have anything to add there?
And no, I agree with you 100%.
Okay. So in this photo here, we have individuals who are on the steps of a government building. I'm not sure which one it is, but they are disabled and they are trying to get access into this building that has a large amount of steps in front of it. They are essentially crawling up the stairs because it looks like there's no wheelchair access, there's no ramp that would allow them to access the space. Okay, so the ADA in higher ed and how it applies. So as I mentioned, Title II government-funded services, programs, and activities includes universities, community colleges, vocational schools, all of those that receive those federal funds, which can include loans, grants, research funding, etc. So because our students receive federal funding for their schooling through loans and Pell Grants, that applies. All of the grants that are received by the universities to do their research work, that's all federal funds, so Title II applies. We have to make reasonable modifications and provide auxiliary aids and services, and they're required nearly always when requested and an individual identifies themselves as somebody with a disability and registers and follows our processes. There are administrative requirements as well, like having a disability services office that manages those requests. And so there's a disability services office on each campus, each of the main campuses at UAA, UAS, and UAF. And then we have people that we work with at each of our branch campuses that also provide services or coordinate services with our offices. Title III, public accommodations. It covers privately funded schools and private businesses. As I mentioned, like the commercial contract on a campus, like our bookstore, they're required to provide reasonable accommodations to give access to the services and the things that are happening in their spaces on their campus. And then they also, auxiliary aids are optional if they present an undue burden or fundamentally alter a program or service that's being provided. So they may or may not have to provide those auxiliary aids, but it's always good practice to look at what the options would be to provide those services. Another thing to think about too, for the campuses that have housing on them, the Fair Housing Amendments Act of 1988 does cover housing accommodations, including things like assistance animals or emotional support animals in residence halls. So those laws would apply to many of us as well.
And public accommodations include accommodations for service.
Good point. And we have another case for Anne to talk about.
So this is a case at North Carolina State University in 2002, where a student requested an ESA and her request was denied. So the reason it was denied is the university said, well, we don't have a policy related to emotional support animals. We're working on one right now, but we don't have one right now. So they denied it, saying that once the policy was written, then the student would be allowed to have the ESA in housing. The student did have accommodations in their classrooms, but was denied the ESA due to the university not having a policy. The university said that it would be a fundamental alteration of their housing program. They stated that many offices had to be involved to write the policy, and it was not clear in their documentation they had discussed the student situation specifically. It was more just talking about the development of a policy. The student was a qualified individual with a disability, had appropriate documentation, and was registered with Disability Services for accommodations. So before Amber changes the slide, anybody want to guess if this was okay? No one has a guess. I can't imagine it was. Yeah, not okay. Lots of people not okay. So the university's concerns did not do an individual assessment of the student's specific situation and specific disability. They violated Section 504 when they denied the ESA. So really the most important, we put on here the takeaways, the most important things to remember. Reasonable modifications to policies, practices, and procedures to avoid discrimination on the basis of a disability. The only way to do that, to say that it's an undue financial burden, that's the only time that it would be approved. And I think Amber would agree that I have not heard any case where a university won based on undue or administrative burden. The University of Alaska gets state funding, so they're not going to look at the University of Alaska's budget to see if we can afford it. They're going to look at the state budget to see if we can afford it. It's really important to think about how people are asking for their accommodations, and again, to investigate whether or not it would be a fundamental alteration or an undue burden on the university to grant it. It's also really important to think about alternative accommodations, and we talked about that last week when we talked about fundamental alteration, to think about, is there another way to meet an accommodation need that would not fundamentally alter the program? And the last one is really, really important, that we clearly document the reasons that we deny decisions. If we are saying no, that an accommodation would be a fundamental alteration or that we can't provide it, we must put down why. And that includes an interactive process with the student.
And we need to provide information on how that student can appeal that and or provide additional documentation. Super important. Does anyone have any questions? Take a pause for a moment. We're going to be getting into some do's and don'ts here shortly. So if we don't have any questions on what we've talked about so far, I do have something I want to pose to see if we can get some thoughts rolling here about what are some things that you think should or should not be done, or that we should be doing or not be doing, given what we have talked about so far. I can hear everybody's keyboards clattering, so I know everyone's trying to type in a message.
Make sure we're following the WCAG guideline.
Yep, that's a definite. So no blanket policies, such as the math department does not allow memory aids. Okay, that's potentially, yeah, we haven't really dove into anything like that yet, but Karen's saying similar to FERPA and Title IX training every year, there should be some training for all of our employees. That's probably a very good suggestion.
It's a very good suggestion.
Clearly stated course
program requirements.
Yep, that's an excellent one. And then faculty should be doing our best to make courses as accessible as possible up front. Yes, that's huge. It saves a ton of time at the end if we do have a student who needs accommodations. All right, we'll move forward. So the do's and don'ts. Obviously, we do not want to do anything that would be a discriminatory action. We do want to do things that provide opportunities for access, kind of along the lines of affirmative action, taking those steps in advance, planning ahead, kind of like that comment about, faculty planning their courses to be as accessible as possible. Doing things preemptively to make sure that we're all set to go and that we're being as accessible as possible. Proactive measures. Yep, Lorraine mentioned in the comments, proactive accessibility measures that include procurement decisions. That's an excellent one. Procurement can be a big area of places where we don't always see the consideration of access being provided. So thank you for that, Lorraine. So in higher ed, affirmative action essentially means or comes down to removing those barriers that don't impact the fundamental objectives of the course or program, but allows the students to access their education fully. So discrimination is a big part of the civil rights legislation that was put into place but applies to individuals with disabilities and the laws that speak specifically to that. So those principles were established by the other civil rights legislation, but essentially it means we can't deny opportunities, we can't provide disparate treatment, and there can't be a disparate impact. So even if without intent, something can have the effect of discriminating. So like if we were to have an off-campus event at a bar that was a fairly old building that didn't have maybe a ramp access into the building, or potentially there was issues with the way that the building was structured, basically prevented some individuals from being able to participate. It's not explicitly discriminatory, but it has the effect of not allowing them to participate with other students, with potential colleagues. If it's a networking event, it could eliminate their ability to connect with individuals who might be able to get them jobs. So there's a lot of things there that would say, let's just find another venue and make it so that everybody can access the space. So unlike other protected classes like race or gender, segregation is permitted when individuals need a higher level of care. But Section 504 states that people with disabilities have the right to receive services in the most integrated setting appropriate to the person's needs. So while we may have an accommodation for distraction and reduced testing, we're going to look at options for something like that. So essentially, the student needs to be able to take an exam in a space that has as few distractions as possible so that they can focus. But that could be that, in terms of the most integrated setting, maybe the instructor is providing a space for them to take the exam while the instructor is there, so they can ask questions if they have questions, just like other students would be able to if they were taking it in the classroom. So we'll look at what's going to be the most integrated setting for that individual in that situation that would work for those involved. Additionally, individuals with disabilities are protected from retaliation and intimidation. So just like our other non-discrimination policies and regulations within the university, if a student is retaliated against or is intimidated by somebody because of a disability, that would be considered discrimination. And hands up with our next case.
So this is a really interesting case that has to do with, there's a lot of stuff, so we'll talk about it and then back it. So a student told a friend, and this is at Northern Michigan University, told a friend that she had a major depressive disorder, and her doctors were concerned about her risk for suicide. And the school found out about it in a report of concern. So that would, at UAA, that's a care team report. And so the school contacted the student and said, we're going to unenroll you because of our policy related to students' self-destructive behavior, unless she submitted to a psychological assessment, signed a behavioral agreement, and did not engage in any discussion of suicidal thoughts or actions with people in the dorm, her friends, or other students. So this has a lot to do with the admission process, acceptance to a major, whether or not students are otherwise qualified to be in a program. So of course, because of this list of things that she was required to do, she sued the college under Section 504. The college said that she did not qualify for reasonable accommodations because she didn't ask. She didn't register with DS, so she didn't ask for accommodation. However, she did identify her disability on her transfer form and on her housing registration forms, and she told her professors and her dean that she had this problem. She also was told that everything would be taken care of by the dean of the college. So it was reasonably conveyed to her that if she notified the college of her disability, that she would get a requested accommodation. What this pointed out is that the faculty and the staff and the deans did not have enough training to know that because the student identified themselves to the university as having a disability, that we do have to provide accommodations. The communication with the faculty wasn't helpful, and the college tried to get this dismissed, but it was denied. Of course, it's a case by case and factual determination, but this student was not seeking accommodations in just one place. She had accommodations granted to her. And she did have accommodations in some of her classes. So we have to be really careful that we're applying the law equally across all of our courses, especially with a specific student. You want to add something, Amber?
A note in the chat from Sue saying, and we wonder why there's a stigma with mental health.
Exactly. And again, this is the kind of thing that happens when we don't have the training. And I love that someone said, we need to have an ADA training, just like we do for corporate entitlement. Pass it back to you, Amber.
Awesome, thanks. So diving in a little bit more into Title II of the ADA, it states that a public entity shall take appropriate steps to ensure that communications with applicants, participants, members of the public, and companions with disabilities are as effective as communications with others. So does anyone have any thoughts as to different ways that we communicate with applicants, participants, members of the public, or companions with disabilities? What are some ways that we provide information to them? Perfect. Through our websites from Kaya, definitely through emails that we send out, word of mouth. Yeah, that's definitely a way that we do it. Awareness building events, right? What if that awareness building event isn't in a space where people can get to? How are we then communicating with those who may not be able to get into that space? Outreach materials, brochures, pamphlets, all of our recruitment efforts, exactly. Commercials, social media, syllabi. Syllabi is a great one. Thank you, Lorraine. Okay, so all of those ways that we communicate with those people on our campuses have to be accessible. There has to be an accessible way to provide that information to those with disabilities. Great feedback there, everybody. So the second part of the ADA there, a public entity shall furnish appropriate auxiliary aids and services where necessary to afford qualified individuals with disabilities an equal opportunity to participate in and enjoy the benefits of a service, program, or activity of a public entity. So obviously for our students who are enrolled in courses, auxiliary aids could include anything from, a standing desk in a classroom to a hearing loop systems for those who have hearing loss, an online option for the student to use a Zoom setup. But what about some thoughts as to what we might do outside of the classroom that still have to do with the university? Because all of those activities still need to be considered for accommodations that might be needed for those with disabilities. So what other types of activities does the university do that we might need to be considering, ensuring that auxiliary aids and services are provided? Commencement, yes, awesome one, Heather. That's a huge one, because that deals not only with those who are on our campuses, but the public. Include the ASL interpreter request symbol and instructions on the bottom of flyers for the community. Thank you, Karen. Yes, definitely, because that's going to be a way of communicating with individuals who are disabled, so or who are deaf or hard of hearing and use sign language. But that's for everything, for all of our events that should be included. Sporting events is a big one. Yeah, how are they accessing the space? Are people able to come in and utilize and participate just as any other individual would be? Yep, great ideas. Other things might be concerts or lecture series from Jen, any virtual events, making sure that those are accessible. So pretty much everything that we do. And then it does note too that the type of auxiliary aid or service necessary to ensure effective communication will vary in accordance with the method of communication used by the individual, the nature, length, and complexity of the communication involved, and the context in which the communication is taking place. So it comes back to this is all set up and has to be set up based on that interactive process and interacting with the individual who's requesting the accommodation to find out what their preferences are and what the situation is, so that we ensure that they have access to it. And then in determining what types of auxiliary aids and services are necessary, a public entity shall give primary consideration to the requests of individuals with disabilities. And this is super important. We give primary consideration to that, their preference, but it may or may not work out that that's going to be the way that we provide that communication. So sometimes we're able to make that work. Sometimes we're not, and we'll provide, as long as we can still communicate or still provide them access. We may have something already in place that would be used, but we do need to consider and determine whether or not that their primary way of communicating or to receive that information is available. So in order to be effective, the auxiliary aids and services must be provided in accessible formats, in a timely manner, and in such a way as to protect the privacy and independence of the individual with a disability. And again, timely manner is really important for how quickly we're able to put those things into place for individuals. And then protecting the privacy and independence so that we're not disclosing information to individuals where it's not necessary about somebody's disability, and allowing them the best opportunity to access that situation, the event, the communication on their own as they prefer it. So reasonable modifications and auxiliary aids and services. This is essentially what disability services on our campuses provide and coordinate, whether it's for an academic situation or other events on campus. It includes all university endorsed activities, which includes extracurriculars, contractors, internships, field placements, field trips. It could be something that's happening on the campus or off the campus. It could be also students who are traveling abroad, doing a study away program, as long as it's a university sponsored activity or the university has some level of responsibility for that, we have to provide those auxiliary aids and services. and or reasonable modifications. So developing the accommodations, it is an individualized and interactive process, really taking into account what the students' needs are, what the situation might be, what is going on with the instructor, what the fundamental objectives of the courses are. All of those things need to be taken into consideration. And that's what the disability services offices do. All of the services must be provided in a timely manner. So if a request comes in for an interpreter for an event, usually what needs to happen is that we have to give some guidance as to what kind of time frame we need to implement that request. But it needs to be provided in a timely manner. And timely manner is in quotes, but we need to do our best to do it quickly and efficiently and get those things in place. So it's important for us to have pre-existing contracts with interpreters or in teletext so that we can request those services from those providers quickly and get them into place. Modifications can be denied if they fundamentally alter the course or the program. And we'll get into that a little bit more later, but fundamental alterations really takes a high level of analysis to determine whether or not it really is a fundamental alteration. But if things aren't listed in a course, the course objectives doesn't list that issue as a fundamental objective, likely it's going to be difficult to make the case that it is impacting the fundamental objectives of that course or class. So academic adjustments, some types of things that are provided could be extended time on exams, digitizing the textbooks for students, providing captioning in videos or in recordings, creating alternative formats for assignments, so digital formats that are accessible by a screen reader, recording the lectures, doing note-taking of some sort. It could be peer or other options. We are, on all our campuses, are moving towards providing other options beyond a peer note-taker because a lot of those systems will allow the student to be more independent and to take those notes on their own, just in a different format than handwriting or at a different time than when they're first listening to the lecture. Sign language interpreter would be an example of an academic adjustment, as would course substitutions that are in a degree program, working with the faculty and the program to determine what would be an appropriate substitution. And then there could also be general adjustments, such as for service animals for students. They're not required to be registered with disability services offices, but we need to allow them on campus as that individual is accessing campus. It could mean architectural changes to make something more accessible. Could be adding a door opener that allows the door to open instead of having to pull it open. It could be that a ramp needs to be installed rather than using the stairs, an elevator in a building that doesn't have one. And then it could be also absences, and that can happen in a variety of situations. One thing that we've talked about actually just recently was, in relation to pregnancies, providing some sort of leave of absence for that pregnant individual who may have complications during their pregnancy to come back into the program without any penalties or restrictions when they're then able to come back.
So Amber mentioned the interactive process, and it is something as DS professionals that almost every training that we go to, they talk about the interactive process. And I would assume the same is for Amber, that if we call the general counsel's office with a question about a specific student situation, the first thing they ask is, have you done an interactive process? So we're going to drive it home for you as well. This win for the interpreter WYNNE versus Tufts in 1991 was a landmark case, and it's referred to often when talking about an interactive process and the requirement for doing that. So this student had a spotty academic record. good in their analysis and their practicum, but struggled with multiple choice exams and really had a hard time retrieving information from memory. The student discovered that he had a learning disability and requested to take all of the exams in essay format instead of multiple choice. The university stated that it would let the court make that decision. But the court found that there was no evidence of consideration of an alternative, and that the school did not address the student's specific circumstances, and that they should have considered that specific situation. The biggest takeaway from Wynne v. Tufts is that there was no way to tell that the university had participated in an interactive process with the student. There was no procedure, there was no process, and there were no notes about it.
So really important that we are following an interactive process and engaging in that with our students.
So here's another one. This is Rose State. The student requested the accommodations, and they requested to use notes on their math exams. And this is actually something that comes up quite often. The DS office told the student notes were not allowed. They had approved accommodations for additional time, for scheduling testing, for reducing distraction while testing, being seated in front of the class, and recording the lectures. The student in the math class and the parent of the student both asked again to use notes for exams. OCR, when this complaint was filed, actually talked to the Disability Services Office, the instructor, as part of their investigation. So what happened? What OCR found was that the college has to have an interactive process to determine if there are adjustments that can be made for a student and their specific disability and their specific program. Again, the college did not participate in an interactive process. Basically, the decision by the DS office and by the instructor showed that they were making their decision based on what's always been done, more of a generalized approach. It would be unfair if the student got to use notes and other students didn't. So having a blanket policy and saying, oh, we don't allow notes on exams is not enough to say that we're following the law. We can't have blanket policies without any individualized interaction with the student and the faculty related to what's required, what's the disability, how is it impacting their ability to show that they are learning and mastering the material. One size doesn't fit all, exactly.
So then we get into enforcement and responsibility. So who enforces these laws and whose responsibility is it to follow these laws? So does anyone have any thoughts on that? Who is responsible to make sure that we are following the laws or that those laws are followed? Who enforces those laws?
Everyone. Everyone's responsible.
Yep. Yep.
Yep, we're all responsible to follow the law.
All right, so on our campuses or within our systems, the enforcers are UA offices of equity and compliance. They handle the grievances internally within the campus for discrimination complaints. And then this is beyond disability services. So we encourage our students to contact us if there's an issue with implementing their accommodations. But if there's concern of discrimination, this is kind of the area that it goes into. So it's equity and compliance on our campuses. And then the Office of Civil Rights, they receive and investigate complaints within higher ed, and they facilitate those resolutions with campuses, just like we had with UAA's case that they worked on. And the Department of Justice also interprets and enforces, and that's who the OCR cases escalate to if institutions aren't compliant or there's a pretty egregious case. And then Title I of issues, Equal Employment Opportunity Commission, the EEOC, is who would handle the employment concerns of discrimination. Within Alaska, there's also different agencies that students can file a complaint with. That includes the Alaska Civil Liberties Union, the Alaska State Commission on Human Rights, and even the Disability Law Center that's based in Anchorage. They can help students work through complaints as well. Who is responsible? So as we already have talked about, everybody's responsible. But when it comes to OCR and who they want to make sure is taking care of any issues that come up, it is the institution that is responsible. That's how they see it. So the institution has to correct those policies and procedures. They don't have jurisdiction over the individuals, but any retaliation by individuals can be pursued in court. And then OCR will work with the institutions toward a resolution. And in situations of continued non-compliance, and this gets back kind of to what the question was earlier about if UAA was to not be in compliance with their agreement with OCR, OCR can freeze federal funding and escalate the situation to the Department of Justice. We don't want to get there because freezing funding means no loans for our students. So then our students can't attend school and it just kind of escalates and snowballs from there. So we don't want to get to that point. But as an individual instructor, staff member, employees on our campus, we all have a responsibility to abide by the request for an accommodation and make changes that are within our capabilities. And we always encourage faculty when they're receiving a request for an accommodation to contact our office, refer the student to our office, open up a conversation with the student to say, can we talk with somebody from Disability Services? Let's connect with them and we can talk through, how to get you connected with them and get you these accommodations that you're requesting. The employees we should all have access to assistance, training, and resources on accessibility that help those or that help enable those accommodations. And that's why we're doing this series of sessions and this conference so that we can further get that information out and provide that training and make it more broadly known that disability services offices are here to help our employees as well as our students to make sure that we're in compliance with the laws. Lorraine asked, are there any plans to provide faculty and staff accessible web design? The ability for departments to update their own web pages could potentially relieve some of the heavy lift for UA web designers and may assist with a timely response when keeping resources current and accessible.
There is web training for Anchorage. I know for sure Michael Tolino Smith does training for accessible web design. Not sure who is doing the initial training for that software for web design. I think it's OU campus. Heather Swanson might know the actual name of that if she's still here.
I am still here.
Is it still OU campus? I'm not sure who's doing the training for that.
It is still OU campus. Currently at UAA, it is IT doing it. However, it looks like Michael Tolino Smith may be taking that over. In order to be able to do anything on the website, you have to complete an accessibility training for OU campus, and that training has to be done every single year. I know that statewide and UAF have just converted from Roxon over to OU campus, and they are working on their trainings, and they are working with Michael to ensure that they have good trainings and that they are accessible also. I'm not sure what's going on with UAS, although I think Colin has been very good about keep making sure that it's accessible. So that's what I know.
Thank you, Heather. So yeah, I think it's select people have access to the the web design for their departments and then their specific training. Thank you, Lorraine.
And we have another case.
Okay, so Rio Salado College, who's responsible? I find this case fascinating, actually. So a student with medical conditions registered with the disability office. They have several academic accommodations, extra test time, testing in a private room, 1 or 2 day extensions as needed for their assignments and their exams. And they enrolled in a biology 100 class and were told that they could only get extensions in emergencies. And the disability office actually advised the student not to take that class, to take a different class, because they knew that that department chair generally refused to allow adjustments and accommodations in their class. So they actually, because of the student's disability, told that student to take a different class and told the chair of the department that they would be recommending a different class for that student. So again, according to the student, they were getting advice about which class to take. The DS people were doing advising to the student about which course to take. The student requested their accommodations in the biology class and it was denied. In the syllabus, it said that they didn't do late work and extensions. The faculty argued that due dates were critical to the learning and the learning outcome of the course, and that turning things in, following timelines were essential for the biology class. So again, we're coming back to that Wynn v. Tufts case where it needs to be an interactive process. If they're giving extensions, we need to know why specifically, based on the course, based on the student's disability. The college asserted that a week was enough time to turn in an assignment. But again, there was no interactive process to make sure that that was true. And advising her differently is discrimination, and requiring her to request permission each time she wanted to use an accommodation. And we have something similar with our flexibility at the University of Alaska, where students are informing the faculty that they need to use their accommodation and turn something in late, but they're not asking permission to use their accommodation every time that they need an extension. Did you want to add something, Amber?
No, that's great. Just the different levels of failure here really emphasizes the point that we are truly all responsible, because this could have stopped at any of these levels. The DS office, the faculty, the chair, and said, nope, that's not the way we're going to do this. But it didn't. So we are all responsible. So injunctive relief. So when there is a finding in an OCR case, what happens? We've talked about some of the cases and some of the resolutions that have come from that, but this is kind of a quick breakdown of what else might be available. So the most common form of resolution is to right what's wrong. It could be changing discriminatory policies, developing new policies or processes. And always, before you do that, make sure you talk with general counsel and make sure that they provide guidance on that as far as whether or not the new policies and processes meet the law. It could be building renovations, such as ramps, changing restrooms, etc. It could be tuition reimbursement, essentially making the person whole again financially, reimbursing expenses caused by inaccessibility, clearing a grade or an incomplete, making it go away so it's not on the transcript, training the employees so that in the future they're following the right process or providing the right information or not being discriminatory, as we saw in the last case. Hiring more staff that are dedicated to accessibility, so expanding the Disability Services Office to make sure that the campus has, the students have more access to those professionals, or that, they can get out, those professionals can get out into the community and provide more information to the campus. Revising inaccessible digital content, and that comes with anything that we put online. It needs to be accessible, if it's especially in a public location where anyone in the public can have access to it. But even in our classrooms, having accessible digital content is becoming more and more important, as people are finding different ways that they learn and study better. Those requests are coming in pretty regularly, even from those who are not disabled. Replacing inaccessible software systems is really important. And even purchasing, someone mentioned in the chat about making sure that accessibility is part of our purchasing process, and really determining, is what we're purchasing accessible. And that's a really important piece, because it has happened where software or equipment is purchased, and then we start using it and realize that we're not able to utilize the system because it doesn't allow for interpreters or for captioning or whatever it might be, but it's not accessible. Damages, OCR and Department of Justice rarely award damages or money for pain and suffering. The proof of deliberate indifference is required, but it's a pretty high bar. But there can be monetary damages that are agreed on in settlements. And as we kind of discussed, if an institution continues to not be in compliance with a resolution agreement, it could mean a stoppage of federal funding, or I would think at that point, if it continues further than that, monetary damages, because at that point, I think that deliberate indifference comes into play. So that's something to be aware of.
There's a request to go back to the Rio Salado case, because she often advises students without disabilities to select classes that fit their learning style or ability to attend classes. So Kim, I think you might also serve as an advisor at your college, if I'm not mistaken.
I do.
So you are allowed to do that.
It's so gray there. I'm confused. That one really took me by surprise. I mean, I've had students say it is with a disability, say they like a student requesting advice on finding a math class that doesn't have so many points associated with a cumulative exam, because they do much better on quizzes. So helping look through old syllabi and finding an instructor that is that teaches the way that student prefers to learn or is better at doing it. That was like their request. And this sounds like advising that student into a class might not have been the best option.
Well, and I think in the Rio Salado situation, it was advising the student not to take a class because that faculty doesn't make accommodations is not okay.
Okay, that makes more sense than not doing it at all or help. I mean, sometimes students don't have great transportation, so I advise them to look at online classes if that's going to help them not be absent so much, so they get more of the learning content.
Our office, we don't advise students, but we do ask questions to help students think about, like, if you moved here from Arizona and you use a wheelchair and you've left yourself 15 minutes to go the half mile between two ends of campus in the snow, they might not have thought about that. Yeah.
All right. Thank you for clearing that up. That helped.
Good question, Kim. There's another comment in chat from Lindsay. I've been disappointed by a few vendors who asserted their technology was accessible, and we later learned it wasn't. Have learned we can't trust a vendor, and perhaps we need a trusted internal expert to weigh in on purchasing. And that would be wonderful if we had that. It's always good to pose it to your campus disability services office. It might be something that we have somebody that can test it, or can have those conversations with the vendor to find out when they say it's accessible, show us that, walk us through how that works. And then we can make a better decision about whether or not that's truly accessible. And Heather noted that we're working on that. So yeah, great. Okay.
The last case, I think the notes for this case got mixed up with an earlier one because this is the one where the student was told, we'll take care of it. Everything's going to be taken care of. So, I mean, you can skip down if you want, Amber, since we've kind of already talked about this. This again is a student who did not register with the DS office, but had indicated that they had a disability, and yet they were denied their accommodations. And this is where the training of faculty and staff is really important on what to do if you know a student has a disability. In this specific case, the faculty did not refer the student to DS and denied their accommodations in their class.
Well, that's right. Yeah. So, Anne, you had talked about, so in this situation, the dean said, we'll take care of everything after the instructor had said that they wouldn't provide the accommodation. And so the courts found that because of that statement and that there were no additional notes in the record in response to her oral requests for help, that anyone told her to go to the Disability Services Office and get registered and go through the process. Essentially, the court said, so sorry, but yeah, you're in the wrong here. It's really important, again, that the training is completed, that we have those conversations with faculty and deans in regards to what's required and really just the ADA. So ultimately, what does this mean for us? We've given a lot of different cases, and we've talked about the different laws that are in place, the requirements that we have to meet as a campus, as disability service professionals. So training of faculty and the academic leadership is essential to ensuring compliance with laws, regulations, and policies in regards to ADA and providing accommodations. It's important for other staff as well, because a lot of times the staff are the ones that are helping to coordinate things. They might be putting on events. So it isn't just our academic colleagues that need that training. Students who request accommodations or tell instructors that they have a disability truly should be referred to disability services, and the instructor should document that interaction for reference. Documentation is a key there, because if it comes back that, no one ever told me that I was supposed to go, we made an error somewhere else in the process, that can, as we've seen in other court cases, could hurt us. Our policies should be written to allow some flexibility with accommodations. Always, never, we don't do these kinds of things. Those statements can be very dangerous, because there's always an exception, right? There's always a student who has something come up in their lives, whether it's, a death of a parent or, a serious injury or situation that they are in where they aren't able to attend class, where we make those exceptions on an individual basis. Maybe the instructor does, or through like the Dean of Students Office or Center for Student Rights and Responsibilities. But without that flexibility in our policies, we end up so that we're no longer following our policies when we make those exceptions, and then it just becomes more of an issue. Our programs should be specific about our eligibility requirements for acceptance into a program or major. We didn't get into some of these cases. There have been cases where an individual who was not able to climb a ladder was in a firefighting program, and whether or not they can perform the duties required in that program, if it's not listed as an essential, here's what the expectations are in the program handbook or that literature, it may or may not be able to be seen as a fundamental objective of the course. And so accommodations may need to be made.
Writing of specific course requirements, not just admission requirements, but what is expected to pass a course, to pass a program of study, to make sure that those handbooks that colleges write for their individual programs are very clear on what's required.
And please contact our offices with questions. We're here to help staff and faculty navigate and implement accommodations just as much as we're here to help students determine what reasonable accommodations they are needing for their courses. So that's an important piece. Essentially, we're here, we're part of a team, and we can, work through that together to determine, what's going to work in that situation. It looks like Kim's got a question.
Yeah, can you make a handbook for any class?
I'm thinking of our CNA classes, which are simply one class, but it's also a program with specific requirements that are different from a regular mainstream class. And I don't know, just running that through.
Sorry, I have the leaf blower outside my window.
The certified nursing assistants class, I know the nursing program is a program and they have their handbook, but the CNA class, which has a lot of those same components, a clinical and a didactic portion of instruction, but it's a class. So it doesn't have that same, it's not a program, but it has a lot of the same outcome requirements.
I don't know that a handbook would be required. It should be in the course content guide, what the objectives, the learning outcomes and objectives of the course are, and how students meet those.
Okay.
Yeah, and you also need to take into consideration what's required for your
Professional life.
Yes, thank you. And for the academic requirements for, yes, the accreditation. Thank you, Kaya. Thank you. You read my mind. So what's required for accreditation? You may not be able to do a handbook or something along those lines, but your program chairs should know better what's required. I would also then send that, any kind of revisions like that, to general counsel to have them look at. And that gets me to the last point here, is that before you make any policy changes, process changes that are going to be published, especially, consult with general counsel and talk with them, have them look it over. You can also talk with them if you need guidance on a specific situation. And we encourage you to reach out to them. We can kind of talk you through a lot, but as far as legal counsel, there are go-tos, of course. They are our lawyers for the university. So it might be good to hear from them as well. That's all we have. Do we have any questions? This was a little bit long of a session, but we went over a lot of important information. So thank you for sticking with us, and we're definitely open for questions. Oh, and Kaya has a question.
I was just wondering, I was thinking about the question about procurement, but what about when faculty are selecting textbooks? Because I know there are a lot of textbooks now that have online components or homework programs. Like where does the responsibility lie for making sure those programs are accessible, because we are requiring students to purchase them?
Well, because you're choosing them, I would say that responsibility lies with you.
Okay.
We are here to help with that. If you're not sure if something's accessible or how it would, be accessible to an individual, where there might be snafus, reach out and talk with us. We can talk with their publisher as well. A lot of times they'll have information about, what's going on, or our offices may have experience with that publisher in the past in those programs to say this really isn't an accessible format. Parts of it are, or there's pieces that work, but as a whole, it'd be better to use something like this. So we may be able to provide some of that guidance. Anne, do you have anything to?
Actually, that's perfect. I think it's really doing some investigating and some testing of programs, especially with the online learning materials, I think is really important.
Yeah, if textbooks are available digitally through the publisher's website, a lot of times there's only like a certain number of pages that are available at one time. And then, so the student may be reading through them, and they may, in other textbooks, be able to highlight information or to gather information, in a way that works for them. And then when they access these websites, it doesn't allow them to highlight, or it doesn't allow them to do some of those functions. It sometimes doesn't even allow them to save the things that they've done. Like if they can highlight, it won't save it when they move to the next section. And so then it's hard to go back and study. it's just that there's a lot of nuances with those systems. So yeah, we encourage you to reach out, talk with your publishers to find out, how does it show me exactly how this works, or show our DS staff how this works. And, we'll set up a time to meet with you.
I was just going to say, I don't have that issue with my own classes, but we see it a lot in the library and the Learning Center trying to help students access those materials.
Yeah, it's not easy a lot of times. And remember too, that when we provide new software for our students to learn, or a new way to, access their information, that's not maybe what other courses are doing, those inconsistencies create a lot of opportunities for non-accessibility to happen, whether it's that they don't know how to use the system, or they have to relearn it, or maybe the keystrokes aren't going to work. If it's somebody who's blind, are they going to be able to use their keyboard to, access that website and that book in particular? So it's really an area that it's important that we check into. So great question. Thank you for that. Lindsay had a comment. I'd be fascinated to hear a little bit about the educational and professional pathway into working in a DS office or in the field. Anne, you want to run with that one for a minute?
Well, I'm like, I have a feeling our paths were very different to how we got where we are.
Yeah, I'll talk about my path, but.
So my education is actually in clinical psychology. I became a certified sign language interpreter 20 years ago. And that's how I started working with students that have disabilities and working in the DS office. And it's taken a lot of time and a lot of working in the DS office to pick up what's required to learn about the laws, and then going to a lot of trainings. And I would say probably 3 years ago, I took over as the interim director, and I was saying that it was learning ADA law and how to address accommodations was like drinking from a fire hose. So you learn a lot and you learn it really fast, but there's a lot of great resources.
My path was very different. I worked in student housing for quite some time, and then moved into the Dean of Students office here, was director of student conduct at UAF for a little while, and the position in this office came open, and they wanted to focus on kind of revamping our policy and kind of restructuring how our office operated. And I didn't have much of a background in disabilities or disability law or anything like that. But my boss thought I would be a good fit. And so again, 4 years ago, I was drinking from the fire hose and attending as many trainings as I could, talking with as many professionals in the field as I could, and couldn't have picked a better field for myself. It was an interesting way to get here, but I really enjoy it.
Yeah.
But psychology, social work, clinical experience, a lot of folks who work in this field have some of that background. There are some programs within the United States that have a disability focus in their program. Some institutions do offer a degree in disability services or disability work in general. The School of Ed, we have the special education programs. That can be a way to move into the field. Occupational therapy is another way that people get access to it.
I feel the way Amber does is a great fit for me. And I really, really enjoy my job. And one thing, to tie it back to the presentation that we kind of have been talking about everything today, is that don't make decisions in a vacuum. Talk to other people. One of the best things I think that UADS has done is that the 3 MAU offices, we meet every week and talk about what's going on. Do we have policies? Where's the problems? Where's the wins? So that we can learn from each other and support each other and basically talk about specific student cases and brainstorm with each other. So Carrie Klein and Jen Malika at UAS, and then Amber and Marissa at UAF, and then me here in Anchorage, and it's been great. And Sue can offer her background too, which is another path that came into to a DS office. So Sue, if you want to share.
Not to put you on the spot or anything.
She offered.
Oh.
Oh, she has to type, she says. Yeah, go ahead and type and we'll keep talking.
Heather, did you have a comment?
I was going to say my road into it was also very different than either yours or Anne's or even Sue's. I liked gadgets and learning about them, and I liked helping people. So that's kind of how I got into disability support services, other than it's always been a thing for me. Even from a little kid, I was always like, hey, that's not right. You need to let them have access, or you need to let them do this. So yeah, I think we've all come at it from different backgrounds, but like you and Anne said, Amber, I absolutely love it.
While Sue is typing, this is Jen in Disability Services at UAS. I was kind of recruited by my predecessor about 9 years ago to just start doing it like literally 15 hours a week. I got recruited. I was a stay-at-home mom at the time and eventually grew into a full part-time permanent employee. And I have a social work background. I'm a bachelor's level licensed social worker. I kind of came at it from the social justice perspective. And then like Anne and everyone else and Amber learned the ADA end of things and the compliance end of things. And it's really been fascinating. It's always changing. I mean, there's no rule book, there's no guidebook, there's no how-to. And that's why this collaboration we're doing is so important, especially for smaller universities like UAS who don't have as the resources that our larger MAUs do. And so it's been really, really valuable.
Thanks for that, Jen. Anne, do you want to read what Sue wrote?
Sure. Sue wrote, I have a K-12 with special ed certification in counseling background, worked with brick and mortar schools as well as homeschool programs, was recruited when my job moved to Fairbanks and answered the recruiter's call. Other questions, comments? Thanks for coming, Lindsay.
Yeah, I think that wraps everything up. So yeah, we have our student panel tomorrow, and we have students who will be answering questions. We've prepared some questions for them, but to respond to, but they'll also be able to respond to your questions. So we hope you join us for that. That's at 10:45 tomorrow. And if you haven't signed up for it yet, you're still welcome to. There's plenty of space. And we'll be sending out the survey this afternoon. We hope y'all got something out of this and are able to take something away. But we really just appreciate you participating and sticking with us through this whole conference. So, Anne, do you have anything to add before we close up?
Thank you all for coming.
Thank you. Have a great rest of your day.